One of the biggest concerns that clients usually have going to trial is the unpredictability of the process, especially when you have a jury trial, which most of our intellectual property trials end up going to a jury. We can't ultimately control what the jury is going to do, but what we can control is our preparation for the trial and guiding it to the outcome that we want.
Since Laurel and I are active trial lawyers, we can explain to the clients what to expect in each stage of the trial. And that gives our clients some assurance as to what's going to transpire over the week or month of the length of the trial. At the onset of a case, you can assess whether a case is more likely to go to trial than not by kind of weighing the strength of the intellectual property that's being asserted, or whether it's subject to reasonable attack, and also the amount of money at issue. And sometimes cases that should settle do not settle because the amount of money that our clients are entitled to based on the strength of its IP is not something that the opposing party is willing to pay to resolve the case early on.
Another thing that's at stake in a trial that isn't strictly relief that can be sought is reputation. Especially with a high-stakes intellectual property trial, you may be talking about a company's most important product that they've built their reputation around. So from both the perspective of a plaintiff litigating their patent rights or other types of intellectual property rights, or a defendant defending against allegations of intellectual property infringement, we handle both of those types of cases all the way through trial, and both plaintiffs and defendants have risk and upside as to the reputation of their company following the outcome of a trial.
We can put together teams of our attorneys and legal assistants that are best suited for whatever the client's particular needs are on a case.